Hello guys, welcome to LawPutra's YouTube channel. Today we will discuss about differentiation in Bharatiya Nagarik Suraksha Sanhita, which will be replacing our age-old Code of Criminal Procedure. I am Jagannath Kulkarni and I welcome you all to today's discussion. Before we start the discussion, let us talk about the history of Code of Criminal Procedure, which popularly is known as, or we call it popularly as CRPC. In 1882, it was first enacted after administration of British India, which is taken over by Crown, subsequent to 1857's rebellion, which we all know. Then in 1898, 1923, 1955, it was most importantly amendment. Though it was amended several times, but these are the particular and typical major amendments. In 1961, after independence, on recommendations of first law commissions, which is 14th report on judicial administration, then again in 1969, recommendations of Law Commission's 41st report for revision of CRPC. In 1970, this CRPC Bill 1970 was drafted, but it lapsed in 1972 due to dissolution of Parliament. In 1972, again it was reintroduced as Code of Criminal Procedure Bill 1972, which was passed by both houses of parliament with 125 amendments. That was in the year 1973 and it came into force on 1st April 1974. Then various amendments were made according to the need of the hour. But in 2013, the major amendment because of the Nirbhaya Act, and in 2014 again because of the Lokpal and Lokayukta Act of 2013. On 11th August 2023, Honorable Home Minister of India, Shri Amit Shah, he introduced three bills in Parliament. First is Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023 and Bharatiya Suraksha Bill 2023, and these three bills will replace respectively Indian Penal Code, CRPC and the Great Indian Evidence Act. These have been referred to relevant Parliamentary Standing Committee and yet to be enacted. Let us discuss about what it is replacing and what is its intention. First is the removal of archaic and insensitive terms. This is the marvelous step against stigmatization. This is the major change has been done. In section 198, section 318 of chapter 15, these words, that is lunatic person or person of unsound mind, they have been replaced with having intellectual disability or person with mental illness. This has been introduced in chapter 18 of section 57, section 219 and clause A of subsection 1 of section 219. This is the reference to Mental Health Care Act of 2017. This lunatic asylum, nowadays it will be called as mental health establishment. Section 10 is deleted because non-existent category of assistant sessions judges. So in judiciary also it is making the changes. Pleader is now replaced with advocate. Section 181 was considering about the term thug. It has been removed in section 201. Also, superfluous distinction has been removed. For example, in section 8, metropolitan areas in erstwhile presidential towns of Bombay, Calcutta, Madras, city of Ahmedabad, any other big cities, they were classified by concerned governments. All are judicial magistrates now, no metropolitan magistrates. Section 153 talks about the police's power to enter and search any place without a warrant to inspect or search for accuracy of weights and measuring instruments. It is obsolete now. Now nobody is using this, so it has been removed. Then section 64, summons could only be served to an adult male member of family. Now in section 432, suspension or remission petitions by only males over age of 18 were subject to higher scrutiny. Now, these subsequently, respectively, these sections have been replaced by section 66 and section 474, where the word male has been rightfully dropped. There is no need to have this gender-based distinction. Now, there is clarity in some procedures in this new Nagarik Suraksha Sanhita. Proclaimed offender, this is the big change in subsection 4 of section 82 earlier. In CRPC, 19 offences of Indian Penal Code, these are the sections which are seemingly arbitrary list of sections. Now anyone accused of an offence with more than 10 years of imprisonment or other special offences will be proclaimed offender. Now section 356 gives the detailed procedure for conducting a trial in case of absence of a person who is declared as proclaimed offender. Section 468 has been replaced with explanation to section 516, which talks about disputes regarding computation of period of limitation have finally been settled. Subsection 1 of section 421 earlier was talking about a coercive actions against people fined for offences. Now subsection 1 of section 462 says coercive action will be taken when this payment of fine has not been made, otherwise not. Just on charging the fine, it will not be made. Also, chapter 25, which talks about 35, which talks about the bail, section 479, it lucidly explains concepts of bail, bond, bail bond, surety. They should have also been explained. Section 473 talks about the detailed procedure for mercy petitions in death sentence cases. Practice of capital punishment or death sentence by itself is inhuman considered worldwide, and it is out of place in several democracies. But Indian criminal justice system still recognizes it. Progressive safeguards and or changes have also been made. Use of forensic science in investigation of crimes. So earlier section 311A, now it is section 349. Now even fingerprints and voice samples may also be taken as compared to just specimen signatures or handwriting samples in earlier iteration of code. Section 293(4) clause G mentioned only central government could notify scientific experts. Now state governments are also allowed. Section 157 has been replaced by section 176 subsection 3. When police receive information about commission of a crime which is punishable for more than 7 years, it is mandatory for forensic team to visit the scene and collect the samples, also cause videography of process. These are the changes which are in tune with technology. Now victim, which was first defined in 2009, now section 209 said during committal proceedings an application filed by the victim shall also be forwarded to sessions court. Now earlier this was 209, now this section is 232. Section 207 said earlier copies of documents, police report supposed to be supplied. Now section 230 says it shall also be supplied to victim or their advocates. So this is again a little change. Now section 249 earlier in complaint cases accused would be discharged when a complainant was absent. This again is major change in section 272. It says an opportunity for complainant to be adequately represented as magistrate can give 30 days time to complainant to be present before discharging the accused. Now section 321 earlier it said while considering an application for withdrawal from prosecution, section 360 now said victim must be heard by the court. Section 200 earlier is replaced with proviso to section 223 which says apart from victims, accused must be heard before cognizance can be taken in complaint by magistrates. So earlier it was not so, now it will be done. Also, section 173 earlier of subsection 2 has been replaced with clause 2 of subsection 3 of section 193 where police is mandated to inform informant or victim about investigation's progress within 90 days which can be done electronically as well, though in some major cities it is being done, but not in all. Section 398 now said all state governments are directed to notify a witness protection scheme. This is again the new section in Sanhita. Then additional safeguards for regarding recording of statements by judicial magistrate. Section 164 subsection 5A clause A said earlier is replaced with two new provisions to section 183 subsection 6 clause A, which talks about if a woman is giving such a statement, it should be recorded by female judge. New provision. Also, when a person is accused of serious offences with imprisonment of more than 10 years, such person's statement must be recorded by magistrate. Now, safeguards for women arrestees, section 46 earlier replaced with provision to subsection 1 of section 43. Now, information regarding such woman's arrest needs to be given to her relatives or friends. Safeguard for anyone who is arrested pursuant to warrant outside jurisdiction when warrant was issued. Section 80 earlier, now subsection 2 of section 82, information about arrested person needs to be given to authorities in district where the person usually resides. So this is again the new change. Section 170 subsection 1 earlier is now provision to section 190 subsection 1. Now, if after completion of investigation but before submission of police report, police are not mandated to arrest an accused simply to secure his appearance before a judicial magistrate. This is the new change. This is the reference to case Satyendra Kumar Anil versus CBI, year 2022 cases of Supreme Court. Section 473A earlier, which was Arunachal Pradesh State Amendment, now it has been incorporated in section 483, which says before a trial or appeal concludes, accused shall be required to execute a bond to appear before next court. This has the positive impact. What persons so concerned need not be immediately arrested for their presence before court. Scope of grant of anticipatory bail is also a major change. Provision to section 438 subsection 1, section 438 subsection 1A and subsection 1B, they were the onerous conditions. The public prosecutor should be given a reasonable opportunity of being heard while hearing application or securing physical presence of accused who was seeking anticipatory bail. While in certain cases it may be necessary to send such information to prosecutor or to secure physical presence, but it should not have been mandatory. The middle path could have been substitution of the word shall for may in both removed provisions. Now new section is 484. Section 436A earlier now replaced with provision to subsection 1 of section 481. Now first time offender pending trial can be eligible for mandatory bail after undergoing 1/3 of punishment as compared to 1/2 of earlier punishment as provided earlier. Also, subsection 3 of section 481 now, it will be duty of jail superintendent to apply for release of eligible prisoners. Section 185 or section 165 earlier, now it is section 105, which says mandated to record proceedings of such search electronically and forward the same to concerned magistrate. This will ensure no excesses are carried out while search operations are conducted by police. Also, copies of any records made during such search now need to be sent to concerned magistrate within 48 hours. This is the amendment in section 185 subsection 5. Earlier no such time frame was there. Section 175 subsection 1 earlier, which was giving power of police to summon people, now provision to section 195 subsection 1, now people belonging to vulnerable categories will not be mandated to attend at any place other than the place where they reside. Also, increasing ambit for provision of legal aid. Section 304 subsection 1 earlier was about the legal aid in a trial before court of session. Now section 341 subsection 1 says legal aid in a trial or appeal before a court. This significantly increases ambit of this legal aid. Human changes to show leniency to first-time offenders in less serious offences simultaneously address issue of rising population of under trial prisoners. This is a big issue in our country. Now, disposal of case in plea bargaining procedure that has been in section 265E, now clause C, clause D of section 293, where it says punishments have been significantly reduced for first-time offenders. Now they can be punished to 1/4. Earlier it was 1/2. Now electronic or digital alternatives for existing process. This is also the major change. It is the commitment towards a digital India. Section 532 says all trials, inquiries, proceedings, recording of evidence therein, examinations of parties, issuance, service, execution of summons and warrants and several other processes can now be done electronically. This is the major change. Also section 62 earlier, now provision to section 64 subsection 2, summons can now be served digitally as well. Now section 70 subsection 3, section 71 subsection 2 says electronically served summons and its digital communication would also be considered valid. Section 204 earlier, now section 227 said issuing summons or warrants under issue of process. Section 134 earlier was about notice by executive magistrate. Now section 153 said it can be done online also. Section 173 subsection 7 earlier, now section 2 and section 207, which was about the supply of police report and other investigation report related documents. Now section 193 subsection 8 and section 230 said it can be done digitally also. Section 371 earlier, now section 412 was about the order of confirmation of death sentence. Section 228 subsection 2, now section 251 subsection 2 says reading of charge of accused under sessions trial. Also section 231 and section 242 earlier, now section 254 and 265, now prosecution evidence can also be recorded via digital means. However, same explicit courtesy has not been extended to corresponding section for defense evidence. So it is only for prosecution evidence by digital means. General explanation under section 532 encompasses all such process including defense evidence. So this may be the reason why it is asking about the prosecution evidence. Also, section 157 was about the statements by police during investigation. Now, proviso to same effect to corresponding section 176 subsection 1 says now may be recorded electronically by phone as well. Section 154 earlier, now clause 2 of subsection 1 of section 173 said even FIRs can be legally registered by electronic communication. Section 182 earlier was about the procedure regarding offences committed by letters etc. Now it says section 202 it includes electronic communication as well. Earlier 451 while considering custody and disposal of perishable property during trial, now electronic records now need to be maintained about the same in Sanhita. Next is the expediting the process and / or making the process time bound. This is very important and which was essentially required by all. Now section 336 says whenever report or document prepared by a public servant, scientific expert or investigating officer is supposed to be used as evidence in a court, then maker of such statement needs to testify before such court. However, due to unavoidable circumstances like death, retirement, inordinate delay, etc., in getting such person, court can secure attendance of successor officer of such person. So there is no need to wait till the concerned officer comes. Even the successor can take his place. Section 251 earlier, now section 274, it is the summons cases, and magistrate for recording reasons can now discharge the accused in with the groundless accusation in case of groundless accusations. So this is also to speed up the process. Section 268 subsection 2 earlier was talking about only state government could have passed notification regarding prisoners. Now even central government in cases of central agency can pass notification regarding prisoners. Earlier section 226 was about the opening case for prosecution in sessions trial. Now section 249 says any other law for the time being in force. This is the major change. Earlier section 306 subsection 2 was about the special judges equivalent to additional sessions judges. They can be appointed under several legislations, different, POCSO and other. Now section 343.2 says special laws could have been appointed under other laws, special judges as well. So other laws are also covered. Section 377, section 378 about the agency under Delhi Special Police Establishment Act. Section 418 and section 419 say now any agency under any central act. So again expanded. Many proceedings under this code, both judicial, executive, have now been mandated to become time bound by providing maximum time limits in which they must be done. Say for example, now section 152, which was earlier section 133, it was for proceedings for conditional order for removal of nuisance. Earlier section 138, now section 157 says such proceedings shall be mandated to be completed within 90 days. So the time binding is there now. Section 155 earlier, now 174, where the police is required to send information regarding NC, non-cognizable offences, to concerned on a fortnightly basis. Earlier section 164A subsection 6 about the medical examination of a victim of rape mentioned without delay, but now section 184 subsection said made it time bound, saying within 7 days of medical examination of a victim of rape. Section 173 subsection 8 earlier about the police investigation during trial, now it says it should be completed within 90 days via section 193 subsection 9. Section 174 earlier was about the inquest proceedings. Now section 194 says police is required to send a report within 24 hours to concerned district or executive magistrate. Section 209 earlier about committal proceedings by magistrate to sessions court. Now it says section 232, it is mandated to be completed within 90 days from date of taking cognizance. This can be extended to maximum 180 days by providing reasons in writing. Section 207 earlier was about the copy of police report and other documents now need to be supplied to accused without delay. Now section 230 says within 14 days. So without delay is now specified concisely, saying within 14 days precision is there, date of production or appearance. Section 197 subsection 1 earlier was about the prosecution of judges and public servants. Now provision to section 218 subsection 1 says if concerned government fails to give a decision about the requisite sanction within 120 days, it shall be treated as deemed sanction given by government. So within 120 days the government has to give the decision. Section 227 earlier, now it is section 250. It says if accused wishes to be discharged in sessions trial, he must prefer an application for same within 60 days of committal. Section 228 subsection 1 clause B, section 240 subsection 1, now it is replaced with section 251 subsection 1 clause B and section 263 subsection 1. It says even charges under sessions trial and magistrate trial in warrant cases now need to be framed again within 60 days of first hearing on charge as per addition to CRPC. Section 235, now it is 258, it says after completion of arguments, judgment of about acquittal or conviction by sessions courts has to be given within 30 days, which can be extended to 60 days only by reasons in writing. Section 246 earlier, now it is section 269(7). It says prosecution evidence can be closed if the witnesses do not turn up despite taking all reasonable measures. This is the pertinent addition to shorten these some trial proceedings. Earlier 219 subsection 1 about offences of same kind within a span of a year, given certain circumstances, person could be charged and tried for maximum of 3 offences at once. Now it is says these 3 not 5 offences it can be done under section 242 subsection 1. Section 281 subsection 5 earlier, now provision to section 316 subsection 4, when magistrate examines through electronic means, his signature shall be taken within 72 hours. So this is mandatory. Section 294 subsection 1 earlier, now 330 subsection 1 says if any party, be it defense or prosecution, needs to admit or deny genuineness of document, they must do so within 30 days of supply of said document. Section 302 subsection 2 subclause, now it is replaced with subclause B to proviso to section 346 subsection 2 says where circumstances are beyond control of party, not more than 2 adjournments may be granted by that party after hearing objections of other party and for reasons to be recorded in writing. Also section 353 subsection 1 now replaced with 392 subsection 1. Judgment in every trial has to be pronounced within 45 days of termination of trial. Section 353 subsection 4 earlier, now provision to section 392 subsection 4 says the said judgment needs to be uploaded online, again technology, within 7 days of pronouncement. Earlier 451, now 499(5), for efficacious disposal and custody of perishable property pending trial, magistrate court shall pronounce order for disposal or custody or delivery within 30 days. Section 453, now it is 501, innocent purchaser of stolen property need to be paid compensation within 6 months. Earlier there was no time frame. So let us see the summary of this Bharatiya Nagarik Suraksha Sanhita when we are comparing it with the which is being replaced statute, that is CRPC. Use of technology and forensic sciences in crime investigation, filing of information, sending summons, other activities are now via electronic communication. This seeks to remove 9 provisions of CRPC, make modifications to 107 provisions and add new sections to original, and this contains 533 sections increased. Earlier there were 484 sections. So this is the summary of this Bharatiya Nagarik Suraksha Sanhita 2023. What is the intention behind this? Intention was from 16th August 2023, it has already been started, the road from 75 years to 100 years of independence will begin. Prime Minister had vowed to end the mindset of slavery. We will bring 3 new laws in there, that is the laws made by British, we will replace them to ensure protection of rights. It will aim to give justice, not punishment, said by Shri Amit Shah, Honorable Home Minister of India, while he puts the bill in the Parliament. So I thank you all for this today's discussion. Today we discussed about the differentiation in Bharatiya Nagarik Suraksha Sanhita and CRPC. Thank you very much.